I think we'll get started. Thank you, everyone. I'm Rachel Brand. I serve as the chairman of the Federalist Society's Litigation Practice Group. Our practice group sponsored this panel, and I thank you all for being here, as well as those of you who are watching the live webcast. The subject of our discussion this morning is entitled Preemptive Rulemaking versus Common Law Redress. That is, should the government impose rules on conduct before the fact to prevent fraud or protect public safety or so on, or should the government allow the private sector to experiment and let litigants and the courts impose consequences after the fact if actions cause injury? This subject sounds esoteric, but it has all kinds of real-world applications. And one of the reasons that it's really interesting is because you could find self-described conservatives coming down on either side of the question. I'm serving as the moderator today, so I'm largely going to take a backseat to our four distinguished panelists, whom I will introduce. I'm going to introduce them very briefly. They all have very fancy credentials, which would take me all day to recite, and I think their bios are in the conference materials, so I'll be brief. After I introduce them, each of them will give brief opening remarks. We'll then have some discussion among the panelists, and we'll then open it up to the audience for your questions. So starting at the end of the table, Brian Fitzpatrick is a law professor at Vanderbilt, where his scholarship focuses on class action litigation, federal courts, judicial selection, and constitutional law. He also serves with me on the executive committee in charge of the litigation practice group, and this panel is his idea, so you can thank him afterwards or blame him, either way. Brian Galle is a law professor at Georgetown. His scholarship covers a range of topics including taxation, nonprofit organizations, behavioral law and economics, federalism, and public finance economics. My notes were in the wrong order, but Michael Greve is a law professor at George Mason University School of Law. It's the Antonin Scalia Law School. Can we call it that yet?
Thank you.
His scholarship has covered a wide range of constitutional law topics, the courts, and business regulation, among many other things. And finally, Adam Thierer is a senior research fellow at the Mercatus Center at George Mason University. He specializes in technology, media, internet, and free speech policy, with a particular focus on online safety and digital privacy. So Professor Fitzpatrick, we'll start with you.
Thank you, Rachel, and thank you to all the panelists. This was my idea, this panel, because I've been very interested in what I have seen as something of a shift of conservative thinking on how the government should go about regulating market behavior. The traditional conservative approach, if you read the Austrian School of Economics adherents, was to rely on ex post mechanisms like common law suits against parties that harm others, that was the best way to regulate. But there's been, I think, something of a change in conservative thinking over the years, and now we see a lot of business interests coming to Washington, D.C., asking Washington, D.C. to engage in a rulemaking or some other agency action that blesses whatever the companies want to do before they do it, and then preempt any common law actions that might occur after the fact if people are nonetheless harmed. And I wanted to invite these scholars here today so we could talk about, what is the better approach? To do it on the front end with a government agency, preempting common law lawsuits, or should we adhere to the traditional approach, which is to let companies do what they want to do, not have to get government permission, but then if they harm people, to rely on the common law. And, one way to think about this is with an example. Suppose you were a car company and you had invented a new diesel engine that had very high performance characteristics, but it did not emit very many polluting particles into the atmosphere. And so we could ask ourselves, how should society respond to a car company with a new diesel engine? One approach would be, before you can put a new engine in a car, you have to go to Washington, D.C., and you have to get a government agency to look at the engine, make sure the engine does what you say the engine does, and if the government approves your engine, you can put it in your car and no one can sue you later if it turns out the engine didn't do what the company said it did. That's one approach. That's the ex ante preemptive agency approach. The opposite approach is to say, if you want to put a new engine in your cars, you're welcome to do it. You don't have to go to the government first. But if it turns out that your engine is not all that it was supposed to be, then consumers can sue you on the back end using the common law of fraud or some other cause of action like that. So which of those two approaches is better? Well, with regard to the first approach, it has the following characteristics. It's ex ante, it's beforehand. You go to the government before you put the engine in your car and start selling it to the public. It's centralized. You go to Washington, you only have one regulator to deal with, and it's centralized. And it's the government that is in charge of whether you're allowed to sell your car like this or not. That's the first method. The second method is the opposite in all of those ways. It's ex post. You do what you want to do, and then we engage in any kind of regulatory behavior after you've already sold the cars. It's decentralized. So you have private parties suing you for fraud in different courts across the country. And it's a private mechanism. It relies on the private attorney general as opposed to the public attorney general to engage in the regulating. I would suggest that for a lot of reasons that conservatives should find appealing, the traditional ex post common law approach is still the way to go on questions like this. And so let me just describe some of those reasons. So number one, conservatives are often very skeptical that government has enough information to make good decisions at any given time. And so when we do things ex ante, we're really relying on the government to collect all the relevant information and synthesize it in the correct way. And if we are cautious about the ability of a central planner to have all the relevant information at any given time, we might be reluctant to rely on these ex ante government approaches when the ex post approach allows us to learn stuff over time. We can get these cars in the market and see what they do and see what kind of information we can glean over time. We don't have to be stuck with only one decision made at the beginning. Secondly, conservatives are very skeptical of centralization. We again learn a lot of information by having different courts, different lawyers taking a stab at these questions. We just have one central planner doing it beforehand. Again, I think we miss out on important information about what these engines are doing and how consumers are perceiving these engines. Lastly, conservatives usually support private sector solutions to problems rather than government sector solutions. And I think there's lots of reasons to like the private attorney general model over a government agency model. For one thing, private attorney generals are very independent of the parties that they are supposed to be regulating. You have a profit-motivated lawyer, and you have a court. And if it's a federal court, they have life tenure. Those folks are independent of the parties that are being regulated, whereas government agencies are often captured by the parties that are being regulated. And so we might be skeptical of the ability of the government to engage in the regulation in an unbiased way. Now, just one last point before I turn it over to my co-panelists. A lot of conservatives, I think, oppose the private attorney general common law model and are seeking preemption from Washington, D.C. these days because they don't like the substantive characteristics of the common law. They think the common law goes too far, and they'd rather have no common law actions rather than bad common law actions. And I think there's a lot of truth to these concerns. The California Consumer Protection Statute is probably too broad. But I would suggest that we should focus our energies on rolling back substantive law that is too broad rather than throw the common law approach out altogether. And I think that's what the efforts to go to Washington to get preemption ultimately do. Thank you, Rachel.
Thank you, Brian. Thanks to the members of the audience also. I'm here for maybe a brief review of the economics of ex ante versus ex post regulation. You can read more about what I'm going to say. I have a recent article in the Vanderbilt Law Review. I should say I'm not a self-described conservative, but I do come down on both sides of this issue. As you'll hear, being an academic, that's what we do. Right? So fundamentally, the question when you're making this kind of decision is, how much are you willing to pay for better information? Brian already talked a little bit about the importance of information. So the more valuable information is, the better the case is for ex post regulation. And of course, the longer you wait, the more information you have, basically. So let me first just be a little clear about what I mean by ex ante versus ex post, because I think there can be some nuance here that's important. So in general, when I say that something is ex ante, I mean that there's regulation before or during the regulated activity. And of course, if the regulation comes afterwards, it's ex post, right? But if you think about it, there are several different components to regulation. There's setting the content of the rule, and then there's enforcing it. And so parts of that process could happen before the regulated activity, and parts could happen after. So for example, imagine a carbon tax. In a carbon tax, we set the price per ton of carbon before the carbon is emitted, and that tax is generally collected more or less at the time that the emission happens. A nuisance suit is the exact opposite, right? It's fully ex post in the sense that the amount of the penalty that the court is going to impose happens after the emission, and that penalty is collected after the emission. Then you have some kinds of regulations, some of the things that Brian referred to as preemptive regulation, which in my mind are sort of hybrids and often get us the worst of both worlds in the following sense. Right? That is, the rule, the amount of the penalty is set beforehand when you have the least information. But then the penalty itself is collected after the conduct turns out not to be compliant. And I'll tell you in a second why that's the worst of both worlds, and it's mostly because there are costs of collecting the penalty afterwards. All right, so the traditional analysis, hopefully that clarified rather than confused the subject of what's ex ante and what's ex post. Now, how do we think about which one we prefer? The traditional analysis, Brian alluded to some of it already by folks like Steve Chevelle, has been that the fully ex post approaches, like tort law, criminal law, the common law methods, right, are preferable because usually information's really important. So to take a couple of concrete examples, think of, let's say, banks. We know we probably don't want systemically important banks to be exposed to too much risky debt. But which banks or other financial institutions, arguably financial institutions, right, in the case of certain insurance companies, are systemically important, and what kinds of debt are too risky? And if we have an answer from government that in some ways errs too far on the side of regulation, we might risk cutting off financial innovation, right, in a way that's costly for the economy. So the argument would be to wait until afterwards, wait until after the bank fails, and then punish it. That way you know which banks failed and which kind of conduct was the kind that crashed the economy. You could tell a similar story about obesity. Right? You could say, society might have reasons, maybe self-protective reasons in an era where we're paying a lot of people's healthcare costs, right, for regulating the cost of obesity. The problem is most of the costs of obesity arise from chronic diseases like diabetes, and we just don't know which people right now are most prone to develop diabetes. Some people can drink soda all they want and not develop those serious complications. If you tell everyone they can't drink soda, you're denying something that makes a lot of people happy to people who are not generating any costs. You can also think of this instead of just thinking about the bad things that we want people to stop doing, think of the good things we want people to start doing, so imagine patents. So which invention has the most social value? I think probably most of you in this room, I think it's fair to guess, don't think that government is good at picking winners beforehand. Right? So it's quite difficult, this is the information problem, right, for a government to know which are the innovation projects that it should get behind. Patents instead wait until after the product is brought to market. And then the value of the government subsidy effectively depends on how popular that product turns out to be. Right, so this is the argument in favor of ex post approach information. But on the other side, waiting isn't free. And this is one of the central themes of my paper. Right? Two of the reasons waiting isn't free are myopia and what I'll call the liquidity problem. By myopia, right, I'm myopic, I think, for ex post sanctions to work, what has to happen? Someone now has to care about something that's going to happen later. Usually that's the case. We care what's going to happen to our future selves, but not always. Right? So think of the bank executive who's going to be retired by the time that their systemically important institution collapses the economy. They can sell their equity stake before the penalty. Or they know that politically it's going to be very difficult to sanction their bank at a time when the government needs that bank to thrive in order for the economy to recover. So you could tell a similar story about obesity. If you're going to have a fat tax, then rather than, let's say, suits against unhealthy food manufacturers, right? In the case of the common law solution, we already have food manufacturers that are selling their riskiest products through thinly capitalized subsidiaries, where almost all the profits in that subsidiary is stripped out through intercorporate debt, which is to say that that sub is almost totally litigation-proof. Is it rational for the managers of that sub to care about later liability? I'd say no. Liquidity's another problem. You could tell the stories like this in the negative externality context. In the patent context, it's very straightforward, right? We know that if you are hoping to get a patent and bring it to market and you're an entrepreneur, the problem is you need money to do that. And that means you need financing, which introduces agency and contracting costs. Right? Basically, you've got to bring outside people into the business, and you have to make sure you're in a position to be able to trust one another. So if you don't believe me on that, you can ask pharmaceutical companies, right? Ask them about the valley of death, which they describe as the period between product discovery and getting it to market, and the huge financing problems they have there. So the question then becomes, how much is information worth? Right? How much of those costs are you willing to take on in order to get more precise, more accurate government regulation? And that's a hard thing, and it's probably going to vary depending on what kind of thing you're regulating. It may also depend on who your government is. But one of my contributions in the paper is just to try to show that we don't necessarily need perfect information and don't have to hope for perfect information. And in fact, imperfect information can be almost as good as perfect information. So for instance, under the right conditions, all you need to do basically to get almost all of the benefits, I estimate about 90% of the benefits of perfect information, that is knowing exactly the costs of every actor in the economy. Right? You can get about 90% of those benefits under good conditions if you can sort everyone into 3 categories: high risk, low risk, medium risk. By the way, your auto insurer already does this. They don't care exactly how risky you are, they care how risky you are within sort of a band. And that's how they do their pricing. So you match your price according to that band, and you get, again, something like 90% of the benefits of perfect information. So just for instance, to be particularly controversial in this crowd, this is one reason why I'm supportive of ex-ante regulation of obesity. Right? And that's because I think it's plausible that we can impose different ex-ante prices for people who are at different risks of serious complications. And for instance, we have good evidence to suggest that people who are particularly impatient and who are influenced in how much they consume by the size of the portion that's put in front of them, right? We know that there's a strong correlation between those tendencies and tendency to develop later serious complications. So what I say is have a tax that scales up with portion size. Or if you're a fan of Mike Bloomberg, anybody here in this room fan of Mike Bloomberg? What? No? Okay. You might say have a cap on the portion size that people can consume. Right? That's effectively a tax on people who are impatient and who are influenced by portion size. It's a tax that really is fairly meaningless to people who are not influenced by portion size. Right? Those of us who are willing to just go back for a second cup of soup. And so again, the idea is that we're minimizing, you might call, the dead weight loss of regulation when we can have multiple prices. And that makes ex-ante systems work. I'll stop there. That's probably more than the brief comments I was supposed to give.
Thank you, Professor Greve.
I just have 2 points, and then lots of arguments pro and con that I can see. I'll mention some of them on both sides, but I have one very firm conclusion. We'll start where, I don't know, who was Brian 1? I think Brian Fitzpatrick is Brian 2? Okay, so I want to start where Brian 2 left off. This is not the first time this debate is being had. Many moons ago, in the early 80s, there was a conference about this at Yale, and one of the principal paper contributors was, I think he may have still been Professor Posner, but maybe he was already Judge Posner. It's this elaborate demonstration. The tort system is efficient. How do we know this? Because if it weren't efficient, it would not exist. And then there is this comment paper by Malcolm Wheeler, who was not just a great thinker, but also a great practical lawyer, saying, with all due respect, the common law system, the tort system you envision has nothing to do with the tort system that actually exists. All of the models, whether it's Posner's model, whether it's the original Austrian intuition, or whether it's some of the more formalized Chevelle et al. Models, all of these models that try to demonstrate the superiority of ex post systems presuppose a great many things, and I don't think we can take them for granted. So most of these models are about, torts among strangers, or torts that for one reason or another you cannot contract away. But by and large, the underlying assumption was that, well, the system, the common law system, will in fact allow you to contract a whole lot of things away through private arrangements, and that those contracts will be enforced. I don't think that's a fair description of what we are looking at now. The system presupposed that we're talking about harms of a certain kind, right? Something tangible, something that actually happened to you, not fraud that has been stripped of detriment and of reliance, not design defect liability that says no matter whether you design the car one way or the other, you're going to be sued and you're going to lose one way or the other, so that the incentive effects afterwards are sort of random events. Those models presuppose one system, not 50 systems that compete for the appropriable rents in the system. And they presuppose sort of an independent liability system, I think, not a system where sort of ex ante regulations then create causes of action, or whatever you want to call it in particular, liability creating mechanisms ex post. And lots of other things you can add to this list, the whacked out incentives of class action litigation, et cetera, et cetera. So none of these underlying assumptions, I think, were realistic, and I think there's nothing bizarre about conservative support for federal regulation of a certain type. That doesn't mean central planning, that doesn't mean sort of Pigovian exercises in controlling obesity or whatever else it is. What it does mean is you rely on central regulation to stem the centrifugal risks in the system, right? And there's nothing new about that, or odd about that. It's obviously in large part a response to modern changes in the system, but to a non-trivial degree, it's just sort of a response to the centrifugal impulses that have been in the system all along. You can call the coastal trading licenses of Gibbon's fame federal regulation, if you want to, but undoubtedly the ruling that this stuff was preemptive was good for innovation. There might not have been a lot of steamboats around, right? It doesn't matter for purposes of the analysis whether you're talking about the tort system or local monopolies. Here's my second point. I think under contemporary conditions, we no longer have a choice between one or the other, ex ante or ex post, except maybe at the margin when you're talking about expanding or extending this or that regime. You always have both under modern conditions in all sectors that I can think of, and very often you have multiple federal regulatory regimes that overlap with one another. You have 50 state regulatory regimes, 50 state tort law regimes, and so the question in those kinds of situations of universal overlap is, what should the coordination rules look like between ex post and ex ante regulatory devices? And there, I agree with Brian, that a lot of this is context dependent. The information aspects that he highlighted are one part of the problem, the error costs, and lots of other factors that I think play into this. All I can do is sort of give you the rival intuitions that play out in this universe and in the debates. So here's one intuition. Redundant systems of regulation are basically good because one picks up slack if the other one breaks down. I don't think that's crazy, but I think it's inapplicable when sort of the conjunction of the regimes cuts in only one direction and when the dynamics of the system dictate that the strictest regulator dominates the entire universe. That's just another way of saying more regulation is ipso facto better regulation, and I can't figure out why that might be the case. Here's another intuition. In a lot of areas of the economy, you're talking about federal regimes that are incomplete in the sense that they offer ex-ante regulation but no compensation for the harmed victims. Food and Drug Administration, Food and Drug Law is an example. Right, so you want to sort of separate this along the lines of insurance functions and compensatory functions. The arguments against that intuition, I think, are that the tort system is a crazy way of providing compensation. And in any event, the Supreme Court has, by and large, at least in the preemption context, gone away from that version or from that way of looking at the tort system and just looks at it as another regulatory and insurance regime. The rival intuitions are, look, what you want to do is sort things and minimize the regulatory overlap. As Richard Epstein and I have once written, one problem, one sovereign. This is true whether you're talking about horizontal conflicts at the federal or state level among varying agencies, or whether you're talking about federal-state regulation. A second intuition is, look, at least pay more attention not to the choice but to the coordination mechanism, right? So think about preemption regimes in various areas of government regulation. To what extent do you actually want the tort law to operate? In what way exactly do you want the federal stopping points or veto points to operate? Think your way through this one regime at a time, pay attention to the context and to the empirics. And the final sort of intuition is that, look, to the extent that we can, maybe we ought to let people opt out of these multiple regimes and sort themselves into one that's more to their liking. I believe that the Supreme Court's otherwise perplexing support for the Federal Arbitration Act, consumer arbitration, and a federal general common law of arbitrability is just a tacit way of saying we made a mess of things and now we have to give people a way out to sort themselves into that regime. And of course, the political apparatus has begun to fight back. I think those are by and large the sort of right intuitions. Although they're very complicated or difficult to cash out in any given regulatory context. The reason why my uncertainty doesn't really matter here is that I believe that our political system has long lost the capacity to sort anything out. You have to live with this multiplicity of regulatory regimes and the lack of coordination between them in other words, it is what it is, which is another way of saying we're screwed and we will stay screwed.
On that happy note, Adam?
Well, thank you. It's great to be here today. My brief remarks are condensed from a piece that I've just posted on the Federalist Society blog called What 20 Years of Internet Law Teaches Us About Internet Innovation Policy. And that is also condensed from a book I've recently published for the Mercatus Center at George Mason University called Permissionless Innovation, The Continuing Case for Comprehensive Technological Freedom, in which I deal a lot with these issues of ex ante versus ex post regulation. Michael just mentioned Richard Epstein, and I'm going to begin by going back to 1995 and referencing a book of his that I think many of you are very much familiar with and big fans of, and that's Simple Rules for a Complex World, which I sort of regard as a sacred text, if you will, on these issues, and in particular explaining the superiority of sort of ex post approaches to policy and relative to ex ante. And generally speaking, what maybe Richard and a lot of us didn't realize at the time when he was writing that book and when he published it in the mid-90s is that essentially we were putting that approach into place as the basis of our nation's internet and innovation policy. We weren't doing it necessarily in a very orderly way. It was a little bit of a mess. In some cases, it was almost a mistake and accident, but a fortuitous one. that we were, in essence, embodying in law two timeless principles from other bodies of law or jurisprudence, one from the field of criminal law and another from the field of free speech jurisprudence. From criminal law, the idea of you're innocent until you're proven guilty, and from the free speech law, no prior restraint. In essence, that became, through a series of decisions both by Congress and the Clinton administration, the basis of America's internet and e-commerce and digital technology policy. We sometimes refer to this as permissionless innovation. It's not my term. I just glommed onto it and wrote a book about it. But people started referring to this idea of the general freedom to innovate without prior restraint, and that you generally are, again, innocent until proven guilty. We shunned the idea of ex ante administrative regulation of this new medium, and we instead relied on an assortment of ex post solutions for when problems developed. There were formal mechanisms, ex post mechanisms, from property and contract law to torts and class action activity, product defects, so on and so forth. And there were other informal ex post strategies, ongoing multi-stakeholder agreements, voluntary negotiations, industry self-regulation, best practices, codes of conduct, transparency efforts, labeling efforts, so on and so forth. So at least for the internet and digital technology, we put a firewall in place, if you will, between the old analog world and the new digital era. We basically shunned the idea of like the FCC and the old ex ante approach, the sort of heavy-handed, prescriptive, precautionary principle-based approach to regulating technology and innovation policy. That's sort of what I call the mother may I approach. And we instead embrace this idea that, you know, you're not just innocent until proven guilty, but you really have a very high standard of proof to determine when you are guilty of something, and you've got to prove it in a court of law, not in front of an administrative agency. So today, we live in a world, a pretty damn good one in my opinion, where 95% of the technology in these devices and these devices does not require any prior approval by anyone in our government. There are, of course, some exceptions. There's some spectrum issues that have to be sorted through and some other things. But the reality is that we do not have a federal internet commission with a bureau of search or a bureau of social networking or a bureau of, you know, whatever. Instead, we allow for these things to happen naturally in the marketplace, and that marketplace has worked out wonderfully. The real-world evidence on this is remarkable when you think about it. You think about the value of tech unicorns. These are billion-dollar tech companies. We've got quite a few of them in this country, trillions of dollars worth of activity. But you compare it to Europe, and we've had an amazing natural real-world experiment going on between the United States and Europe over the past 20 years since we put in place our approach, our ex-post approach, and Europe was still trying a very heavy-handed, top-down, command-and-control, ex-ante approach. The results have been amazingly clear. In Europe, they have about $120 billion worth of tech unicorns. Apple alone is 3 times that size. Facebook is twice that size. Airbnb, a company that no one in this room would have even heard of 5 years ago, is already bigger than all of Germany's tech unicorns. These are amazing results, and there has to have something to do with policy, I argue in my book. Now, we are, of course, wondering what happens next. Can we preserve that model? I think there are clear benefits to it, but there are always people questioning it. As Brian number one mentioned in his remarks, there's a problem. We face sort of a crossroads, if you will, in the field of law and innovation policy in this country. First, for the reasons that Brian suggested, because there are many companies, including many internet and digital companies, that have sort of feel like, well, we had our day, we got our permissionless innovation, we did great, but maybe now's the time for more prescriptive regulations or a little precaution. Now, one reason they might do that is because as they mature, they might look at law as a benefit to them to hold off new innovators. New rivals. It's sort of the public choice story, right? The other reason might be something that Michael alluded to, which is that there may be a case to be made for a certain amount of preemption of state and local activity, or maybe harmonization at the international level. Either way, there are certain calls being made increasingly for maybe changing the sort of approach that we've adopted over the last 2 decades for the internet and digital technology. But there's a second reason that we're at a crossroads in the field of law and innovation policy in this country, which is that, as venture capitalist Marc Andreessen has famously said, software is eating the world, and the ramifications of the digital technology and revolution are starting to permeate every single sector of our economy, from drones to driverless cars, from advanced medical devices to virtual reality to 3D printing to digital currency and Bitcoin and so on and so forth. But the problem is each of those new sectors is butting up against the old world, the old ex-ante world of regulation, because of course a lot of those sectors come out of or flow out of technologies or sectors that were essentially, as I say in the book, born in captivity as opposed to born free. A lot of modern internet technologies were born without these constraints and without these agencies. But now for each of these technologies I mentioned, the primary examples are driverless cars, advanced medical innovation, fintech and Bitcoin. Well, these are the most heavily regulated sectors of the United States economy. So something's got to give because we have the collision of permissionless innovation and the precautionary principle. So I guess that raises the question, will simple rules for a complex world prevail, or will we get far more complicated rules? And how do we stop, if you were like me, you want to preserve the idea of permissionless innovation and the sort of ex post approach and all its benefits? One way to do it legislatively is to try to make sure that we continue to firewall off the new from the old. The problem is that sort of throws a lot of the old players under the bus, but that's sort of exactly what's happening today in a lot of these fields, especially the ones I just mentioned, transportation tech, fintech, health tech, and some of these others, because old players are heavily regulated. Along comes a new entrant from, say, the sharing economy like Uber, playing by a totally different set of rules, and they get away with it, right? Now, in my opinion, that's not necessarily a bad thing because it shakes up policy. But what we're essentially seeing is a sort of the creation of an asymmetrical regulatory playing field of sorts, with some being winners and some being losers. I'd like to see the playing field level in the direction of more freedom, sort of deregulating down as opposed to regulating up. It's not always easy, but it's sort of happening anyway. There's a terrifically interesting article that recently appeared in the Harvard Business Review called Spontaneous Deregulation. And the author said what we're seeing in a lot of these new sectors is spontaneous private deregulation where no law changes, no regulations change, but somehow everything changes. And that's exactly what's happening in the sharing economy. It's partially what's happening in the world of fintech with Bitcoin. It's certainly happening in the field of FDA regulation, where I'm noticing the FDA struggling to figure out, is this a smartphone or is this a mobile medical device? They're not sure. They're not sure how to regulate it. Same with 3D printing. If you create a 3D printed prosthetic for free on a voluntary basis and give it to a child with a limb deficiency, have you violated FDA regulation? You probably have, but the FDA is not doing much about it. So we're seeing spontaneous private deregulation of some of these sectors and technologies. Whether or not that balance will remain, or whether or not the sort of empire will strike back and impose an ex-ante regime, remains to be seen. I'm working hard with some others right now on an idea that I came up with my colleague Eli Dorado, of the idea of an innovators defense fund, which is basically sort of like an IJ or a Goldwater kind of thing for technology policy. Basically finding a way to defend the innovators of the future, to get them legal support when they butt up against the old ex-ante regulatory regime, and they don't have the resources of a Google or an Apple or a Facebook. And that's going to be launching soon, I'm proud to say, and hopefully that will provide another way to defend this. In the legislative arena, to wrap up, is there anything that can be done? There were a lot of good reforms that were mentioned earlier on today on the first panel. I don't have a lot of hope. I spent the first half of my life, the first 25 years, trying to advance those reforms and getting not very far, almost nowhere, in terms of advancing positive change. In my lifetime, no major economic sector has been deregulated. We keep telling the old stories. Do you remember the old days when we deregulated airlines and trucking? Yeah, they were great, but they're hard to remember, right? And so I'm getting very frustrated with the pace of legislative reform, but that's okay, because we live in a world where these digital technologies and a lot of these new sectors are disrupting law and providing a chance for us to open up the door to more ex post adjudication. My friend Larry Downs wrote a book called The Law of Disruption. He says the fundamental law of the information age is that technology evolves exponentially and policy evolves incrementally, and the gap between them grows every year. And my job is to make sure that continues, and to make sure that we defend the people who are on the cutting edge of that curve of technological disruption. Thank you.
Well, thanks to all of you. Let me start by asking if there is anything that another panelist said that you must respond to. I don't know, there was a reference to whacked out incentives of class action litigation. Brian, I don't know if you want to respond. If there's something that any of you would like to say in response to another panelist, feel free.
I would like to say a couple of things in response to what Michael said. So Michael says none of this matters because we're going to be stuck with a lot of ex-ante regulation and a lot of ex-post regulation. But I think that's too pessimistic. And I think that if we're going to try to reform in either direction, we at least need to be clear about what our end goal is. And that's why I think this discussion is important. Is our end goal a lot of ex-ante regulation, or is our end goal ex-post regulation? And once we get that in our minds, then we can have a directed discussion about how we can best accomplish it. So I don't think that it is a discussion for naught. And, you know, one of the points that I think has to be made in this discussion is, you know, the virtue of the ex-post decentralized approach is that mistakes are much less costly. You know, when the government tested Volkswagen's diesel engine, the government thought it was fine. And if that had preempted any kind of ex-post remedy, then we'd have a lot of people that have no recourse because the government made a mistake about that engine. And when we have a decentralized ex-post approach, mistakes are much less costly because they don't affect everyone in a uniform way like an ex-ante approach does. And I do like Adam's example of the driverless car. I think that's a great example to have this discussion around. Do we want to wait for the government to approve a driverless car before any of us can have one? Or do we want to let the manufacturers put them out there and then wrestle with the tort lawyers when the inevitable accidents ensue? I guess I'd rather see those cars on the road more quickly rather than later.
Go ahead.
So a couple points. One, to pick up there where Brian left off. I think it's important not to confuse the ex-ante, ex-post question with the regulate or not question. And Adam described a world in which there are no ex-ante regulations as one in which organizations are born free. But I think if you talk to the lawyers at Google who talk regularly to their insurance underwriters, they wouldn't describe themselves as born free at all. Right? In fact, you know, one of the biggest problems for the driverless car is the potential liability. And you can bet darn well the insurance underwriters are thinking about that. And even if, so the point is the possibility of some ex-post regulation becomes ex-ante because there are people who have an economic interest in making sure those ex-post effects are thought about, right? And similarly, Airbnb, right, one of their crucial moments in the firm was deciding how much they were going to promise their landlords, their mini hotels, right, that how much Airbnb would cover damages. And that again was a decision that they made, and then they got a huge amount of pushback, as I understand, from their insurer. So again, just the more general point is that this question of ex-ante or ex-post can be separated from the question of how much regulation or who regulates. And then similarly, you know, not to criticize Brian, but you know, there are moments where he seemed to assume that ex-post regulation necessarily was juries and ex-ante regulation was necessarily agencies. But the reverse is also possible, right? That is, you could decouple institutions from timing if you wanted to. Ex-ante regulation is also very familiar to us in the United States. It's just the injunction, right? Before you can, you know, the famous Boomer cement plant, right? Whether or not there should have been an injunction before they could open or damages after. The second point that I can make, maybe just briefly in response to Michael's really interesting remarks. So I think Michael generally is someone who's a fan of federalism and experimentation. And I think appreciates usually the value that we can get from observing 50 different regulators and seeing which ones went right and went wrong. And as I understand, your point is that we don't really get that often. And instead we get, you know, the harshest regulator is the rule that everyone has to follow. And then you don't get experiments. And I just think, you know, that can happen sometimes. But I think it's the exception rather than the rule. So I think the example you might be thinking of, for instance, California's vehicle safety rules. Which become de facto the way that all auto manufacturers have to manufacture their cars. Right, but what about Berkeley's sugar tax? I don't think that the city of Berkeley has a sugar tax right now. That doesn't, as far as anyone's been able to tell, seem to have changed the way that, you know, beverage sellers are operating. And so we have an experiment in Berkeley to see how it's going to go. And maybe it'll turn out that it didn't go well, and then it won't spread. Maybe your view is different about what's the
I mean, it's, I don't want to have a debate or open a debate about how often does this happen, right? So what do I know? I think it's true of a whole lot of products, certainly of things that are sold in national product markets, and that cannot be easily kept out of any given market, right? I mean, with respect to products that you can actually physically keep out, I mean, from sale in any given jurisdiction, I suppose I'm by now sufficiently despondent to be in the Atlas Shrugged debate. Just boycott those states.
Adam, is there anything you wanted to add?
Yeah, just briefly, I love the driverless car example because it's a really nice one. It's instructive of like what potentially are the costs of an ex-ante regulatory regime. Here's the operational baseline in the debate over driverless car technology. Every day in this country, 92 people die and 6,500 plus people are injured in automobile accidents. 90 to 95% of those accidents are caused by human error. So any potential thing that we do that slows down the advent of technologies that could reduce the amount of human error behind the wheel is something that has real-world human consequences every single day in the United States. Those are risk trade-offs that our regulators sometimes ignore because they're so hyper-cautious about saying, well, oh my gosh, if you remove the steering wheel on this car, we can't possibly let this get on the road because how could you take control of it? But that's the whole point. We don't want people to take control of it, right? And yet that's happening in California today. Google is not allowed to create a driverless car and experiment with it that does not have a steering wheel. And yet it could, and it would be safer. So now there is a legitimate risk, and this is something Brian number 2 just raised, about what happens if these cars get on the road, and these driverless cars, intelligent vehicle tech, and there's an accident. And there will be an accident, no doubt about it. There won't be nearly as many as when humans are driving them, but there will be accidents. You better believe the trial lawyers are going to pounce. They've already tried to suggest that there may be a way to go after Google for like the one accident that they could find. So that's a legitimate problem. Now, I would argue that there are probably reasons to consider maybe providing some legal immunity to these driverless cars manufacturers for the kind of things they're creating. We've been here before. We've been here for childhood immunizations in the 80s when the trial lawyers went out and were suing left and right the drug makers for making vaccines for kids that could save lives. Congress said, why aren't you creating more life-saving drugs? And they said, because we get sued every time even one kid gets sick. So they created a compensation fund to say, okay, you'll be immunized, but if there is somebody that gets sick, we'll compensate them out of a fund raised by a small fee on that drug. That's probably a better model because a lot more kids' lives are being saved today because of it, and there isn't as much trial activity. There's also a model from firearms, right? We don't allow fire manufacturers to be sued frivolously anymore after the law we passed in the early 2000s. There's also a law from the internet space, something called Section 230 of the Telecommunications Act of 1996, immunized online service providers from liability associated with the third-party activities of downstream actors. So if you go on Yelp or eBay or some other service and you say something that other people find offensive or even defamatory, you, the intermediary, cannot be held liable for it. This is the whole reason we have services like Yelp and eBay and YouTube and all the others. They would not be able to exist if they could be sued out of existence every time somebody was offended by something that was placed on one of those sites. So somewhere in between all of those potentially lies a hybrid model of indemnification or immunization for life-saving, life-enriching technologies that we want to see get out on market, but otherwise will be screwed over by tort lawyers.
So can I jump
Very briefly.
Yeah, so again, I think there's a conflating of no regulation and regulation. So the vaccine compensation fund, that's a carbon tax for vaccines, basically.
Yeah.
Whereas the other things you're saying are total immunity. So I would, I think I'm in favor of the vaccine model and maybe not in favor of the total immunity.
And I guess I don't see why we have to immunize Google from what happens with their driverless cars. I think that Google should be liable if they create a car and it malfunctions and it ends up in an accident. And I think if we were to ask Google, would you rather wait around for the government to approve your car and tell you how many steering wheels it's got to have, or would you rather just be strictly liable for any accident that happens with your car and you can design it however the heck you want to? I think Google would choose the latter approach.
Maybe Google would. Google could probably afford the lawsuits and the liability, right? It's all the other innovators that I think we're worried about there. I'm not saying we should automatically preempt that because, of course, obviously we're going to see a liability shift away from the end users, the drivers and owners of cars, and towards the fleet providers such as Google and Tesla and others. But there is a legitimate question: at what point do we have a human? There's a serious cost in terms of public health, because if we could actually decrease all of these deaths and everything else associated with human error behind the wheel, that would be an amazing public health success story. But I don't think there are going to be too many manufacturers that go forward with this stuff if they're sued out of existence.
Are there, for those of you who favor ex post regulation or imposition of liability, are there certain areas of regulation, are there certain areas where everybody could agree that ex ante regulation is good, either because of an inability of consumers to make informed judgments, or food safety, I don't know. Is there some area like that where you would diverge from your general antipathy toward ex ante
Yes.
regulation? What would it be?
In my book, I have a section on when does precaution make sense?
Okay.
When should we have ex ante rules? And we need to have a high bar, a strict standard that, in my opinion, comes down to the question of when the harm in question is highly probable, tangible, immediate, irreversible, and catastrophic. Now,
Can you give an example of that, a concrete
you can flesh
example?
it. Well, sure. We don't allow people to roll down the road in tanks and carry surface-to-air missiles on their shoulders, right? I mean, there's two examples. We don't allow people to possess uranium or mercury. There are all sorts of other regulations of an ex-ante approach that are very much hinged on the harm in question.
What about regulation of things that normal consumers use or want to use?
So it may be that there are certain types of food additives and certain types of medical devices that do necessitate greater precaution, but there also could be maybe a hybrid approach where you allow for a certain amount of experimentation and you better educate people about risk trade-offs. I'm doing a paper on this right now about risk education in the context of 3D printing. There are all sorts of people doing crazy interesting things with 3D printers and medical devices, not all of which are necessarily smart. But they're doing them voluntarily in a decentralized basis and not a commercial basis, and there's no way the FDA can control that. So even if you want ex-ante regulation there, it's not going to work. So what they have to do is rely instead on some sort of a risk education model where they say, yes, we know you can do this with a 3D printer, yes, we know you can do this with a smartphone, yes, we know this with that, but you may not want to for these reasons. So you maybe shift the regulatory playbook from ex-ante controls to ex-ante education, with a lot of post adjudication after the fact.
Other panelists have a thought on that? Brian, is there some area where you would?
Well, I mean, I think Adam's right that when the harm is irreparable, then all of this, information gathering we're going to do over time is really not very valuable because people are dead. And so I think that has to be the focus of the ex-ante approach. I don't want, though, you can always tell a irreparable harm story, and so I don't want to open the door so wide that we end up just stuffing everything in the ex-ante closet. And but I do think that irreparable harm is probably the touchstone of that. Now, some people point, I mean, the regime in this country that we have is most dependent upon the ex-ante approach is the Food and Drug Administration. Before you can market a pharmaceutical or medical device, you've got to get their approval. Some of those drugs pose irreparable harms, and maybe that is wise, but a lot of them don't. And there's a lot of people that would be willing to take experimental medications that have not been shown to, be safe and effective just because the alternative is dying, and they'd rather give it a chance. And so we can have irreparable harm from waiting too long to allow a company to sell people stuff, just as readily as you can have irreparable harm from the company selling you stuff. And so I think it can cut both ways, irreparable harm. So I think it's really hard to decide when the ex-ante approach is really worth keeping things out of people's hands. I just would rather the public make their own decisions about what's good for them rather than the government.
Let me ask a different question. Go ahead.
I think it's impossible to answer in the abstract because you're always asking compared to what, right? So it's a relative comparison to the private world, or not, but the ex-post world. Let's call it that. I agree with Brian on that point. That's out there. So if you look at Brian 1's example about these experimental medicines not proven safe and effective, if the people who say, I come forward, I want to take this stuff, I'm fully aware that this is experimental, if you're going to actually sort of immunize the provider and producer against ex-post litigation risks that, never mind, I didn't know what I was signing, I was desperate, and my aunt was distracting me. If you can make that bargain, that contract stick, that's one thing. If you're living with a tort system that says, never mind what they signed, that's another thing. And so it depends.
Let me ask about another distinction. So Brian Galle pointed out that you shouldn't conflate ex ante, ex post, with regulate or not regulate. I think when Brian Fitzpatrick's talking about ex ante, ex post, you're really talking about ex ante government versus ex post private. What about the distinction between ex ante government versus ex post government? So if you take the FTC, for example, they don't really regulate. They come in after the fact, imposing some rule that no one's ever heard of and nobody can comply with, and that's the allegation anyway. Do you have thoughts about that dichotomy?
Yeah, I think it's a great question, and I guess I'm skeptical that government is going to do a good job ex post as well, largely because I'm concerned about the government being captured or otherwise biased by industry or anti-industry forces, frankly. I mean, do we want the CFPB, deciding when things are okay or not okay after the fact? And so the nice thing about the private sector, the private attorney general, is it's independent. It only cares, the trial lawyers only care about one thing: can I make money on this case? And so long as we're shaping the remedies appropriately, we can control those incentives. But the government is very hard to control when you have lobbyists and others that are influencing what those ex post regulators do. Also, the truth of the matter is, insofar as we like the underlying regulations, insofar as they're enforcing horizontal price fixing or breach of contract or fraud, and we like the underlying regulations again, I just think the private sector is going to do a much better job than the government sector of robustly enforcing laws we like. The private sector has a lot more resources to throw at these problems than the public sector does. The public sector is always strapped for cash. We want a public sector strapped for cash in this room, right? We don't want to pay the taxes to support a big government. And so I think that relying on the private sector, even compared to the government ex post, is still the conservative way to go.
I actually have a view on this, which is that once upon a time, it's tempting to think of there are private enforcers and there are public enforcers. This is now analytically and economically somewhat different from the questions we've been discussing, but I think it's right to go down this path. One of the things that has happened over the past 20 years is that the line between public and private enforcers has become increasingly brittle and indistinct, let's put it that way. So, key TAM enforcers, who are they? Public, citizen suit organizations, what are they? Public or private? What are they after? Profits or the public good? The line between trial lawyers and state AGs is increasingly indistinct. All the difference, so far as I can tell, is that the state AGs have a badge and the trial lawyers don't. Right? And so if you sit on the defense side at one of these big firms or in a general counsel's office, what you're confronting is sort of an ecology of law enforcers. Some public, some private, somewhere in between. They all cooperate, they all compete with one another for sort of being the first in the door and the most aggressive enforcers. That's the reality that you're dealing with. And as for the distinction, well, the public enforcers, they're really after the public good, except they may under-enforce, whereas the private enforcers, they're motivated by profit, and so therefore they come in. All sorts of problems with that. Among the problems, it seems to me, is that it's not clear to me at all that public enforcers are still motivated by maximizing public benefits or look away from the profits. You look at these DPAs and NPAs that swirl around. There are thousands of them. Meanwhile, you don't know what they're enforcing. You don't know why they're enforcing it, against whom exactly, whether anybody did anything at all. All you read in the newspaper is that another $12 billion have changed hands. So I would be that's one aspect of the sort of conjunction between regulatory regimes that I've mentioned at the front end. And that goes not only for sort of ex post versus ex ante mechanisms, that also goes for the enforcement side, and it's a big problem.
Just say a brief word about FTC here, because it's probably in the context of when you're studying modern law and innovation policy, one of, if not the most important agencies in the federal government. First, a word of defense for the FTC's model, which is generally speaking more of an ex post enforcement adjudication model, once you figure out what are unfair and deceptive practices or antitrust violations. That is certainly superior to something like what the Federal Communications Commission does, with a prior restraint approach to sort of what is in the public interest, and then coming up with ex ante rules, very meticulously detailed rules governing and licensing communications and media technologies in this country. Whereas the FTC at least allows for these things to develop and then decides, okay, is Google guilty of something? Is Facebook guilty of something? Is Apple? And they have gone after all of the household names in the tech economy for various types of supposed Section 5 unfair and deceptive practice violations. Almost all of them are under consent decrees right now with the FTC. So some of that I'm a little bit worried about. Neil Chilson's here with Maureen Olhausen. Maureen's going to be here talking about these issues today, and she's written eloquently. She's a commissioner with the FTC, eloquently about these issues, but pointed out there are some reasons to be concerned about sort of overzealous ex post enforcement activities like this. 20-year consent decrees on companies that might not even be around in another 5. You know, MySpace is under a 20-year consent decree, and it's like, MySpace, really? So you wonder, like, the scope of that sort of thing. There's also another thing that's very important here. What the FTC has been doing is employing an old playbook, but in a much more aggressive way, as have other agencies, which is sort of using best practices and agency guidance, industry guidance, and workshops and public statements to essentially create a sort of what they regard as a body of law for all these emerging technologies. I think there's an implicit understanding by the FTC, its staff, and many others like them, that they cannot possibly keep up, and nor can any other agency, with all of these technological innovations. But they can put the fear of God in some of these people's hearts by basically saying, well, we're going to have a workshop on biometrics, a workshop on Internet of Things, a workshop on drones and driverless cars, and all of these things they've had FTC workshops for. Big data, you name it. And we're going to come up with best practices and codes of conduct that we want you all to follow. And then hanging in the root is the sword of Damocles that is Section 5, an unfair and deceptive practices authority, saying, well, you know, you're free to do any of this, but can we remind you we've got Section 5 back here? And so it's the fact that the sword hangs, not that it falls, that becomes the enforcement mechanism. And that's the new mode of governance for most of these emerging technologies. It's a model that's being picked up by the FDA, by the FAA for drones. The FDA is doing this for 3D printing and virtual reality and some other things, and every other agency. So are we comfortable with the idea of agency threats and this sort of like soft law, soft governance approach to innovation policy? I'm very torn about it. It's better than the old command and control ex ante strict defined approach, but it's also incredibly arbitrary. And it's not even clear, like, what are your rights to appeal this or FOIA it or whatever else. It's all ambiguous and unclear.
Brian Galle, did you have anything that, didn't know if you're raising your hand earlier or not?
I have views on this, but I'm happy to hear the next question, too.
But are there questions from the audience, or I can give, if there are, go ahead and there's a microphone in the aisle.
Thank you all very much for such interesting remarks, but I was hoping the panelists could talk about an area where I think it's a much closer call, at least in my view, where we would want ex ante or ex post rules, and that's perhaps in antitrust enforcement. I can look at, for example, the concerns about Blockbuster acquiring Hollywood Video and find those to be laughable now. But on the same token, I think there's also a good argument that maybe the wireless industry was better off by not having AT&T and T-Mobile come together, and maybe the government got that one right. And to the question as to whether or not the private sector would necessarily police price fixing, for example, better than enforcers at DOJ or FTC. I mean, a lot of the economic literature shows that cartels were very difficult to detect, even with the incentives to cheat, until the DOJ instituted its leniency programs. So, I mean, I think there is perhaps an argument that I hear the side of, well, the merger review side can be filled with horse trading and appeasing the various interest groups. But I think there's also something to the idea that, as was said many times, you can't unscramble the eggs when it's all done. And do you want to be subjected to a treble damages lawsuit that's going to go on for years and be very expensive to try? Or would you rather just have an enforcer on the front end say, we think your deal's anti-competitive?
Thanks. Anyone on the panel want to take that one? Go ahead.
Because it connects with the observation I was going to make about the previous comment. Again, distinguishing ex ante, ex post from the choice of institution, right? Whereas Brian points out there may be differences in propensity for capture or outside influence between the jury system, let's say, and a regulator. And I think abstracting from that, right, in general, ex post is a situation where it's more difficult to get the regulation to the level that objectively we think it ought to be because there are more rents there, right? Once the merger has happened and the organization has market power, it's bigger, it's richer, it's got more influence, and also it's a more tempting target for government regulators who want to hold it up. Right? So whether you think there's going to be too much regulation or too little, either way, ex post, we have a little bit of the danger that now we have an institution that's entrenched, and I think antitrust gives you a good example of where that happens.
You know, I would just say that, you know, relying on the private sector ex post doesn't necessarily mean that there should be no ex post government activity. And so I think you're absolutely right that sometimes the government is going to be in a better position to do things ex post than the private sector would be. And, you know, I think sometimes in securities fraud, sometimes in antitrust, the government has more resources at its disposal to get information to detect the underlying harm. And so I think there is something to the notion that you want to have a diversity of ex post enforcers so that when one of the enforcers is incapable of performing, that you have another enforcer there that can pick up the slack. And so there may be some opportunities for that kind of redundancy in the antitrust price fixing area. You know, there are empirical studies that have been done of price fixing enforcement that compare the government versus the private lawyers. And what the studies suggest is that there are many more examples of private enforcement where the government didn't do anything than there are examples of private enforcement that piggybacks off of some kind of government activity. And the evidence also suggests the private enforcers recover a lot more money than the government does, even when they sue in the same cases. Now, Michael would say that's because a lot of these antitrust class actions are you know, being settled for too much money because the companies are you know, over a barrel. But you know, I'm not so sure that's the case. So I think that even in the price fixing area, and even when the government can help, I think there's still evidence that the private sector is doing a better job than the government in many ways, and is an important resource to keep around, even if we're going to have the government enforcers around as well.
All right, next question.
Right, thank you. I'd like to shift gears a little. Adam, you talk about patents and prior approval. So an average smartphone has, you know, a few thousand patents in it, and patents can be a form of prior approval. So how do we balance, on one hand, you know, this theory of permissionless innovation, and on the other hand, property rights, especially for smaller entrepreneurial ventures that don't have money or litigation power of Apple or Samsung?
Oh boy, intellectual property. Nothing creates a fight in a room full of conservatives and libertarians like a good old-fashioned fight over copyright and patents. I wrote a book for Cato Institute in 2002 on intellectual property, tried to be a peacemaker and stake out a common ground solution. I made so many friends on both sides of it so angry with me, I promptly dropped the issue and never wrote on it again. It's not easy. We don't have permissionless innovation for you know, patents and copyrights with good reason, because you want to incentivize obviously a certain amount of creativity, and that requires some restrictions. There needs to be some constraints on that, and I think we've gotten things a little bit out of whack in recent years, and I'm sure there will be some in the crowd who disagree, but things like software patents and business method patents have gotten completely out of control on the patent side, and really hindered a lot of interesting and important innovation. And on the copyright side, we've always gotten things a bit out of whack with our expanding terms for copyrights. There's no possible reason I can conceive of to incentivize people who are long dead, and yet we do Life of the Author Plus as our standard today.
But wait, it incentivizes their kids to go through their belongings to see if there's a manuscript in there somewhere.
Yeah, I guess so. But yeah, so I mean, there's a real tension there. In the book, I don't spend a lot of time with it, but it's clearly one of the major fault lines in debates about innovation policy, and it's one that's particularly difficult for conservative and libertarian types, and I'll just leave it at that.
Anybody else? Otherwise, next question. Thank you.
Thank you all for your comments. I wanted to go back to Rachel, your question about, are there some areas where we just want ex-ante regulation, or we can agree on that? Excuse me. And then Professor Greve said that, well, of course, it's all contextual. It's hard. So I'm wondering, I want to throw this out for consideration of the panel. Maybe there's some more intimate connection between letting ex post rules do their thing, let the common law try to sort things out. And then if that doesn't work out, and I think this is probably how it works anyway, for whatever reason over time, the common law fails because bringing a suit is too expensive or burdens of proof are too hard, then we decide, okay, we've learned enough over time that the common law isn't working in this particular area because of information asymmetries or whatever other reasons, and then we make ex ante rules. But with the whole universe of ex post information that we've already developed about these problems as the common law has tried to sort it out. So I'm wondering if we really have to decide this question, Rachel, that you pose in the abstract. Are some things ex ante, some things ex post? Why not just let the ex post systems kind of work themselves out? And can we come to agree that sometimes they don't work? And in those cases, we can try prospective rulemakings for those problems.
Anyone have a thought on that, Brian or Michael?
Look, there's something conceptually elegant and attractive about that, and it accommodates sort of various camps, conflicting or differing intuitions. I can envision, and maybe if you give me 10 minutes, think of examples where it worked that way and something reasonable came out of the effort. I can also think of examples where the process was described that way, and out of it came a complete disaster because once the legislative or regulatory process responds to what happened in the tort system, it makes it worse. And then that becomes the floor for the next round of sort of tort litigators to sort of ramp it up one more step, right? The development of state general anti-fraud statutes in the states is that example. I mean, it was, reasonably contained, looked more or less like FTC enforcement of, fraud statutes. The sort of what counted as a fraud was not exactly identical, but it has some rough similarity of what a common law system would define as fraud, right? And then these people went in the states, went on a rampage because they have incentives that sort of the FTC doesn't have. And every time something came, some court invented some new form of fraud or some new predicate for, what ought to be considered as fraud. State legislators put that into the general fraud statutes, and then it was off to the races yet again. So, and you don't know in advance whether the process will have that dynamic or the more hopeful and fruitful and sensible and let's all be reasonable dynamic you described.
Brian Galle, or either Brian?
Well, I just wanted to say that I guess I'm just skeptical that we've ever learned enough and can freeze into place at one time what the results have been from the ex post process. I think things are always changing, and what seems good today may not be good tomorrow. So I'm reluctant to freeze things into place with ex ante rules after some period of ex post activity, because I think there's probably going to be new learning that comes out of the ex post process if we were to have allowed it to continue. So I guess just as from a theoretical standpoint, I just worry that we maybe never learn enough, that there were always more to learn.
Can I just respond?
Hold on, I want to let Brian Galle speak because he's been we're trying to get the microphone.
No, that's right. I think what's been said, I agree with. Right? You'd love to experiment. You worry that we might get stuck with past dependence or a result that we end up not liking, but the system turns out to be stickier than we thought. I want to experiment. I agree with you.
Michael, go ahead. If you...
I'm just not sure about the generalized assertion that government doesn't learn and sort of the private sector out there or whatever it is, ex post, we learn a lot. There are areas of tort law and private law where we don't know or don't learn a damn thing from it other than, hey, somebody, once wrote a memo saying this could go wrong. Yeah, there's a memo for everything saying this could go wrong. That's the only thing you learn in these big trials. You learn nothing about the product itself. What could we conceivably learn about global warming by ex post litigation? I don't know. And conversely, I don't want to make this too polemical, but it already is, so I'll look, the government is very, very efficient at learning certain things, right? It has become much more efficient at scaring the bejesus out of people without ever writing a formal rule. That is a result of a government learning process, and in some ways, agencies are very, very efficient at sort of picking up things. You just have to give them the right incentives.
Next question. Go.
Yes, Ramon Buehler with Madison Coalition. Both Michael and Adam have talked about this new form of regulation, regulation by fear. And I wonder if anybody on the panel has a view about whether it would be better or worse for the regulatory process if regulations, like laws, had to have the consent of Congress. There are 11 states which now have processes where regulations have to be approved or can be blocked by the legislature. They have arguably a pretty good regulatory experience, but I'd be interested in whether people think that something like the REINS Act or the Regulation Freedom Amendment would improve the regulatory process or stifle it.
The question here is it the regulatory process as defined by the APA and our other types of guidelines for these things when agencies involve themselves in informal rulemaking or guidance procedures, right? And that's the really tricky question here, because a lot of what the FTC is doing and these other agencies, they'll just say, well, there's no law here, there's no regulation. Of course, there kind of is, but they're just saying we're providing industry guidance. We got a bunch of stakeholders together, we convened a table of multi-stakeholders, and they came up with these policies, and they all agreed to them. And we think that's great. Well, of course, hanging in the room is that threat that, like, if everybody else doesn't abide by those, then you know what hits the fan. But what about the innovators of the future? What about the innovator that's not even at the table, hasn't been invented yet? It's not entirely clear what happens to them. I don't know if the REINS Act or anything else applies to this, but this is the defining issue of our time for law and innovation, in my opinion, is like, can we make our peace with this regime in the short term while we sort of bide our time to get more sort of innovation wins in the marketplace? That's the name of the game for me right now.
Anybody else? Otherwise, next question.
Hi, my name's Austin. I'm a philosopher and a theologian by trade, so I don't know much of anything really about the policy intricacies, you know, that you've been talking a lot about. My primary and very deep interest is in a lot of the more fundamental ethical implications of a lot of what you've been talking about. And you know, back in the 50s and 60s, Hayek and Kerzner and all of these great exponents of the Austrian school were doing a lot of talking about epistemology and you know, how government knows what it knows, if it knows what it thinks it knows. And so I'm just wondering if you could speak a little bit more. You've mentioned it a little bit, sort of tangentially in some of the things you've been saying, but if you could speak a little bit more about sort of this gap between what we need to know and what we do know before promulgating a regulation. At what point is that gap sufficiently filled, you know, before promulgating a regulation? Thank you.
Who wants to take that?
It's a tough question. As you suggest, there are philosophical answers, there are also economic answers. There's a recent article, I'm not coughing to the microphone, so I have it coughed up. Recent article by Alan Schwartz, who's a Yale law professor, who suggests that, for example, the CFPB shouldn't be regulating consumer contracts because some of those contracts might be efficient for some people. And this is another way of saying we're not sure exactly what the costs are of regulation for everyone. And what Schwartz says is when we're not sure, we shouldn't regulate. That is, you might say, if you're thinking, I'm a tax guy, I think of everything in tax terms, right? If we think of what's the tax we should impose on this contract, he says it should always be zero until we're 100% sure. And the point of my work is I think that's wrong. And I think the reason it's wrong is if you had a 50% possibility that a contract would cost $100, and from society's point of view, and a 50% probability that it would cost zero, putting a price of zero on it is just mathematically the wrong price. It should be $50, That's the price that maximizes social utility. Right? So that's to say that there are a few different ways of approaching it. I'm not sure what the philosophers would say, but I think that's the basic economic take. You don't need certainty.
You know, I think the most powerful insight from the Austrian school was humility, that the government and even we don't know what we don't know. And so it's very hard to take products off the market at any given point, I think, and that was my response to the earlier question, was I don't think we've ever learned enough, in my own view, to take products off the market. I think that we ought to let consumers decide for themselves whether they want a product. I don't think the government knows better than we do on what we should be able to buy. And so I don't think we ever fill that gap. You know, these products may be good for some people even if we don't understand it, and things can change over time. And so I don't agree with ever freezing the market in place because we've had some period of experience. I say we leave it open and let people choose for themselves.
So far, I think, for the most part, we've sort of assumed that ex-ante regulations would be, don't do this, right? Or minimum standards or quality standards. There are different forms of ex-ante regulations that sort of go to your problem, it seems to me, and try to solve this. So if you don't know what you're doing, right, maybe one of the things that government could do is to provide default rules. There are lots of examples of this, of the way this works. So you provide a default rule that's easy to contact around, easy for people to get out of. And if it then turns out that later, I mean, somewhere down the road, nobody uses the default rules anymore because some other form proves sort of more sensible or efficient or desirable for market participants, you haven't lost anything while still sort of having provided some form of, if you want to call it regulation, call it regulation. By the same token, I think one of the things that's desperately needed in many, many areas of regulation is, and this came up in the sort of talk or discussion about sort of regulatory dark matter and these guidance documents and stuff. To my mind, the bad thing there is not that, oh, they don't go through all this formal rulemaking rigmarole. That's frequently silly. The problem is there are no safe harbors. And so if you could have more sort of regulatory devices, which would also be ex ante, would say, look, we haven't made up our minds about a whole lot of things in this arena, but for the following things, we'll give you a safe harbor. We will not consider the following 15 things abusive, which is in fact the form of regulation that most of the regulated industries want. So there are forms of regulation that sort of recognize the problem here. You don't know, if you don't know what you're doing, don't try to do too much, but give people a way to go about their business.
Okay, last question.
This is just a follow-up, so thank you for letting me ask another. I really want to push Brian with an example, since he used the theoretical abstract as a kind of an out. So a book just came out, and this is why this example is in my mind, called Arresting Contagion, written by two economists. Very, very interesting.
Sorry, Elon, what was it called?
Sorry, it's called Arresting Contagion. I think it was Harvard University Press about a year ago by two economists. Interestingly, for this crowd, they try to argue that the modern administrative state should be dated to 1884. With the Bureau of Animal Industry rather than 1887, the ICC. I think they're probably wrong about that. But in any event, the example here I think might push Brian to give an answer, but maybe not. I just want to see. And so there was this issue with tuberculosis in cattle where there was a test that was developed by the private market, and if there was a positive test for tuberculosis, for 90 days, the cattle would not be responsive to those tests again. So often you would have cattle farmers, ranchers, testing their cattle. They tested positive for tuberculosis, and then they would sell them because other farmers or retailers or wherever wouldn't be able to test. For 90 days, they would get these false negatives. And there were some attempts at lawsuits, but they were expensive, they were slow and laborious, and there were proof issues since there's lots of exchanges going on. And there's a public health problem here because the Bureau of Animal Industry, in theory, wanted to stop, they wanted to arrest this disease. And so eventually they made prospective ex-ante rules. They said, okay, for 90 days, any of these cattle that test positive with this can't be sold. They can't be sold. Doesn't matter if there's a buyer willing to buy it with the risk, because there's a public health concern here, and there was this technological problem, and the ex post tort system couldn't work it out. That's just one example, and I think, Brian, you know me, I'm pretty sympathetic to your view on this, but there's got to be some thing that we give here, I think, sometimes.
Well,
We've got 1 minute till lunch. So.
One of the traditional bases that a libertarian is willing to engage in this kind of regulation is to control negative externalities. And, some of these public health situations fall into that category. And so this may be one of them. I have to think about it further before I endorse any particular ex-ante regulation, but certainly negative externalities are a possible reason why we might want to do something along those lines.
Thank you to all of our panelists.
Thank you.
This is very interesting.